Hello, my name is Sarah Garvey. I'm counsel in the litigation department at the international law firm Allen & Overy. I'm going to speak today about a new European regulation called the European Account Preservation Order. I'll refer to it as EPO during the course of this presentation. I will discuss the upcoming changes and the open issues that arise as a result of this new instrument. Now, by way of background and by way of preliminary introduction, I would outline that this is a very complex instrument. There are 51 recitals to this piece of legislation. There are also lots of references to national law, so practitioners will have to get used to combining both European legislation and national legislation to provide advice. There are also certain gaps at this stage. We don't have information from the member states in relation to certain of their procedures under this new regulation. So the other point I would make by way of preliminary introduction is that there have been lots of alterations during the course of the legislative process, and the final version of the instrument does contain a number of differences from earlier drafts. So it's important for practitioners to become familiar with the final text of the document. So during the course of this presentation, I'm going to discuss the following issues. I'm going to have a look at the policy backdrop to the instrument. I'll outline what an EPO is and when you might want one. I'm going to consider what the best jurisdiction to get an EPO is and what the threshold, what's the test for obtaining such an order. I'm going to consider whether claimants need to provide security when applying for an EPO and what are the other risks for claimants in obtaining such an order. I'm also going to outline how the EPO can be used to obtain bank account information and what the practical issues will be for banks implementing such orders. Just pausing there, this instrument is of huge importance to financial institutions operating throughout member states. It's also obviously important to litigants appearing before member states, but financial institutions will be responsible for implementing these orders, so they will need to ensure that their systems and processes are ready for the moment that this regulation comes into force. Finally, by way of looking to the future, I'm going to outline certain predictions for this regulation and its implementation. So, first of all, what is an EPO? Well, an EPO is a cash account freezing order that will be available from member state courts from the 18th of January 2017. It is a single uniform court application available to those domiciled in participating member states, and it will be effective in all participating member states. That is, all member states other than the UK and Denmark. Now, just pausing there, the UK has announced that it is not participating in this measure, and Denmark has chosen not to sign up to this measure. So it's going to be effective in all participating member states, but that will not include the UK and Denmark. The other aspect of this jurisdiction is that it appears that claimants the only claimants that are able to obtain such an order are those domiciled in participating member states. Now, this would appear to be the result of certain text that's introduced by way of recitals, so we'll have to see whether or not there is a subsequent challenge to this nationality test, essentially, introduced by the text in the recital. There may be a legal challenge to its legality. So then just moving on, the EPO is considered to be an alternative to existing preservation remedies that may be available to national courts within the European Union. The EPO will be available before proceedings are instituted, during proceedings, and after judgment. So that is a quite wide-ranging remedy. They will be available for cross-border matters in civil and commercial proceedings, and the test is pretty wide in this regard, but it does not apply to arbitration. The application procedure is generally ex parte and on paper. By ex parte, I mean, of course, that a party applies, only one party is a party to the application for an EPO. You do not have to give notice to the other side. That would defeat the surprise element needed to preserve accounts. But the other interesting aspect of such an application is that they are generally made on paper, meaning there will be no hearing before a judge to obtain such an order. Now, for English common law lawyers, this is very different from the English common law system that grants freezing orders and relief, where your ex parte application, a claimant would make, they would submit papers, but generally appear before a judge and be quizzed as to their parts of their application. So there's no hearing ordinarily in obtaining an EPO. The next point to note is that there will be a significant degree of discretion for participating member state courts in the application of this regulation. And as noted at the outset, there are a number of areas where there's quite a complex interplay with national law. So you have EU law to be read alongside applicable national law, which leads to some complexities. So why might you want an EPO? Well, it's obviously going to be an aid to enforcement where there are multiple accounts of a defendant. So it means that a claimant will no longer need to go to the courts of participating member states and make individual applications. You can just make an application to one member state, and that order will be transported across to relevant participating member states for its enforcement. Now, it's going to be especially useful, it is suggested, for SMEs, small and medium enterprises, post-judgment, where generally the requirement for security will not exist. So that should aid enforcement, it is thought. But I would just flag at this moment that the Brussels recast came into force on the 10th of January of 2015, and as a result, enforcement of member state judgments across other member states has been improved and simplified with the abolition of exequatur. So it may be that, in fact, that enforcement process is already relatively straightforward. There's also, you may also want an EPO to obtain disclosure of account information. Now, the circumstances that you can get such disclosure are relatively limited, and I'll come back to that point shortly. You may also want an EPO because the national remedies may not be available or assist you as a claimant because the test is too high, or there are some other aspects of the national process that don't suit a claimant's needs. So it just may be an attractive alternative to any national remedy. So what's the best jurisdiction to get an EPO? Well, there will be, as I indicated, some differences in the application and and national law may vary. So, for example, national law may mean that certain member states have certain requirements for security or with relation to the liability of the claimant, should the EPO be found to have been wrongly granted. And the result is that it might make EPOs from certain participating member states more attractive than others. So there is, I anticipate, a potential for forum shopping, because the application made to participating member states courts with jurisdiction over the substance of the matter, that is, unless the debtor is a consumer or where a judgment has been issued. It may be that a claimant has a choice as to which jurisdiction to initiate proceedings. The creditor is only obliged to describe all relevant elements supporting jurisdiction and not elements against, although there is a requirement for a declaration that the information is true and complete. And it's also unclear to what extent the court that receives an application for an EPO will investigate its own jurisdiction. And there is some uncertainty about the status of an EPO where there's a jurisdiction challenge. So I think the upshot of all of this is that we may see some forum shopping, and it may be that parties over time recognise a particular member state as being possibly more liberal in their granting of EPOs, and that may have a knock-on implication for the selection of choice of court agreements, with parties choosing that particular court for the resolution of their disputes, or indeed avoiding that particular court for the resolution of their disputes. So one important aspect of the new regulation is the threshold, the test for obtaining an EPO. And this was subject to a lot of discussion and amendment during the course of the legislative process. It was said that the initial draft of this measure, there were concerns expressed by many commentators and others that the test was too low, it was too claimant friendly, and the early drafts did not sufficiently protect defendants. So it seems that a number of the amendments introduced during the course of the legislative process have been addressed to this very point. So where we end up is Article 7 talks about sufficient evidence that there is an urgent need for an EPO, because there's a real risk that without such a measure, subsequent enforcement will be impeded or made substantially more difficult. You need to demonstrate as a claimant a real risk that by the time the creditor is able to have the judgment enforced, the debtor may have dissipated, concealed, or destroyed his assets, or have disposed of them at an undervalue to an unusual extent or through unusual action. So that's recital 14. Now, in the pre-judgment context, you need to demonstrate sufficient evidence that the claim is likely to succeed. So this is the substance of the claim. So that's at Article 7 as well. And you also need to initiate proceedings. That's Article 10. Now, I anticipate there may well be a divergence between member state courts as to the standards applied in considering this test until there's decisive European case law in this area. The question is, what is sufficient evidence? One court may take a very different view from another in this regard. And also remember that this is an application that is ordinarily made on paper. So without the judge being able to ask follow-up questions to seek clarification in the way that they would at a hearing where the claimant's lawyers attended. So the test, I think there may be divergence in the approach by member state courts to its application. So one important question, and it relates to the application for an EPO, is whether claimants need to provide security. In the pre-judgment context, the final version of the regulation indicates that yes, generally they do. There is a small business debt exception, but generally claimants will be required to provide security. Again, this seeks to balance the rights of creditors and debtors, claimants and defendants, to maintain a sort of balance between their rights. In the post-judgment context, then generally no, security will not be required. The amount of security should be sufficient to prevent abuse and compensate the debtor, the defendant, for damage to the extent the creditor, the claimant, is at fault. But again, the question is, well, what is sufficient? And I think it will be open to different courts to take different interpretations, or they may well do, until there is sufficient case law in this area. In the absence of specific evidence as to damage, it's open to the court to consider the EPO amount as the guidance, so the amount sought in the order as a guidance. The form of security will depend on the law of the participating member state of origin. So again, you are likely to see divergence between participating member states and potentially a knock-on impact for forum shopping. There is some uncertainty about when security might be released and whether the creditor can recover its costs. So what are the risks to claimants when applying for an EPO? Well, Article 13 sets out certain situations where they'll be liable to a defendant. A claimant is presumed liable in certain circumstances. For example, if there's over-preservation. A claimant may also be liable to third parties or a bank. Again, these circumstances are set out in Article 13. Another practical issue is that actually the requirement to provide security may give rise to certain cash flow problems for a claimant. It may depend on the form of security that is required, but conceivably it may cause real practical difficulties for a claimant. And in fact, the provision of security may in fact prove to be a deterrent to the application for an EPO. It may prove to be an unattractive alternative to national measures in certain situations. For example, if a member state court under its national measures will grant injunctive relief at an early stage of proceedings or even before proceedings have commenced, without the requirement of a claimant to provide security, then it may be that a claimant chooses to apply for a national measure rather than an EPO for practical reasons, possibly concerning cash flow issues. And this may be a situation where, for example, claimants in proceedings in Holland may prefer to apply for national measures rather than the new EPO. So how can an EPO be used to obtain bank account information? In the EPO application, a creditor or claimant must either provide an IBAN or BIC or other number and or the name and address of the bank, or request that the information authority, the IA, in the participating member state of enforcement obtain such information. Now, requests for information, however, can only be made post-judgment. So that account information, if you don't have it available in the pre-judgment situation, you can't ask for it. It's the post-judgment situation where it's relevant. So further issues to consider when seeking to obtain bank account information as an EPO. An information authority in a participating member state of enforcement must act expeditiously. A new national legislation may be needed to provide the information authority with the mechanisms to obtain that information. Information obtained is then provided to the requesting court, but not to the claimant, not to the creditor, and notification of a data subject is deferred. This information aspect of the regulation is likely to impose a burden on banks, and banks will need to ensure they have systems in place and their terms and conditions are assessed accordingly. So what are the practical implications for banks? Well, as I've indicated previously, there are likely to be significant obligations on banks. First of all, they must freeze any accounts without delay and provide a declaration within 3 days of implementation that they've done so. There are also the account information requirements that I've just referred to. So what accounts are covered? Banks will need to be clear about the location of any named account. The extent to which joint and nominee accounts, however, are frozen is going to vary across member states. The extent to which the freezing of joint and nominee accounts is permitted is going to depend on national law. So this is Article 30, national law of the participating member state of enforcement. So there's again going to be divergence on this very important issue between participating member states and, for example, jurisdictions that recognise trusts and beneficial interests may impose EPOs on a wider range of accounts than others. An express order may be required in the place of enforcement to freeze such accounts, and therefore no single application mechanism will be available in such circumstances. So the one-stop shop of the EPO may not work in those circumstances. Another question is whether funds are covered. Money or similar claims for the repayment of money are described in Article 4. Another question is how are exempt amounts to be dealt with, those amounts in the account that are not to be frozen. Now, the regulation tells us they're to be determined under the national law of participating member states of enforcement. There are questions, however, as to how and when these amounts will be communicated to banks. And again, we may see quite wide divergence between participating member states as to what's an exempt amount. The other question is, well, are incoming funds caught by an EPO? Further issues for banks to consider: how are over-preserved funds to be dealt with, where the EPO covers several accounts or was issued after the implementation of an equivalent national order. The creditor must initiate the process to release the over-preserved funds and is liable for damage caused to the debtor where he's at fault. In other circumstances, for example, bank error, the liability is determined under the national law of participating member states of enforcement. One very important issue, but one where there are still question marks, is, well, what about the rights of set-off of a bank, and what about the bank's potential liability? It's said to be determined under the national law of the member state of enforcement. That's Article 26. So just turning now to consider some issues looking forward. The first is the creditor nationality requirement. I indicated at the outset that there is likely to be a potential challenge to this nationality requirement. Recital 48 talks about the regulation applying only to those member states which are bound by it, but then continues the procedure for obtaining an EPO, should therefore be available only to creditors who are domiciled in a member state bound by this regulation. So it would appear that UK, Danish, or indeed other non-EU creditors, claimants, cannot obtain EPOs, even in circumstances where their co-claimants might be able to. So what to expect when this regulation is introduced and in force? Well, undoubtedly, it will be a tool to aid enforcement. The post-judgment EPOs are likely to assist enforcement across member states. It will be another tool available to judgment creditors to ensure that any assets available across member states are not dissipated before enforcement actually takes place. In the pre-judgment situation, however, the security requirement and the complexity of the instrument may discourage uptake. And it may be that this is not an instrument that is relied upon by vast swathes of people across member states. I think there are likely to be very real differences in approach between member states, and this may well give rise to a degree of forum shopping. And certainly those differences will continue until there is a solid case law of the ECJ established on certain points of principle. There is likely to be an increase in the burden on banks who have to not only freeze accounts, but also under the account information requirements, find out information about customer accounts and transmit it quickly. And as I said, there's likely to be an early legal challenge on the grounds of the creditor nationality. But I think it will be an interesting area to watch. Thank you very much for listening.